And is it right to do a will or a deed?
That's part of what I should have said as well. It's one of the ways to prepare for death that you get your will ready. It's incumbent. In fact, the hadith says that a Muslim must not sleep for 3 nights without having his will under his pillow. But remember that will under Islamic law is different from the will in the conventional. You are not allowed as a Muslim to distribute your property among your heirs as you wish, because Surah An-Nisa, verse 11, 12, 13 has apportioned the rights entitled to by each and every heir. Allah has settled that. And the Prophet ﷺ had said, خُذُوا عَنِّي قَدْ أَعْطَى كُلَّ ذِي حَقٍّ حَقَّهُ فَلَا وَصِيَّةَ لِوَارِثٍ. Take it from me. Allah has given all heirs their entitlement. Therefore, there is no more bequest for legal heirs. What I mean is, you can't say my house in Ikoyi number so. I bequeath it to to Bola. My this, you can't say that. I always advise that because of the society we are, where we find ourselves, in a society where the law of Islam does not operate, you can still find a way. What you do is you execute an Islamic will, and that is, you have just 4 assignments to do. The will declare yourself as the testator. Then you appoint your executors. Let's make that paragraph 1 of the will as what? Appointment of your executors. Paragraph number 2, you declare who are your heirs from your wife or wives, and then your children and whomever is legally entitled to inherit you. Paragraph number 3, whatever you can capture in terms of your properties, you list. The landed, the chattels, you list them. That I am the owner of this. Very important as well, if there are things that can be backed with necessary particulars, let it also go. Then paragraph 4, you instruct your executors, named in paragraph 1, to distribute your properties listed in paragraph 3. Among your heirs listed in paragraph 2, in accordance with the provisions of Islamic law. If you like, state specifically Quran chapter 4, verses 11 to 12. That is a valid will. It meets all the requirements of the Wills Act or the Wills Law, and it can be duly admitted as well to probate. That's free legal advice. You don't need to pay for it. So, all you need to do is get your executors, and if you do that, you are free. You see, sorry, this is not our point. No parent can ever be fair enough. If you want to take charge of the distribution, you may also be creating problems behind you, and you may also be, committing a crime that will also endure after you, and that you will not also have the opportunity to correct. Are we there? If you don't trust anybody, appoint is just another suggestion. You can appoint the Sharia Court of Appeal, Kwara State, Ilorin, as your executor. It's a statutory body, I'm saying. It's a statutory body. It's a creation of the Constitution of the Federal Republic of Nigeria. Appoint that entity as your trustee. And whenever the time comes and your will is read, the Grand Cadi or whoever is there knows what to do. It's going to be distributed, inshallah. That's better.